Molt bé, gràcies, Carlos. Potser per introduir el debat sí que, no per fer valoracions, que ja les heu fet totes vosaltres, que sou els que domineu el tema, sí que com a introducció del debat o una primera pregunta que jo faria és la qüestió del tractament de la responsabilitat i la diferència entre el tractament de la responsabilitat i com ho tractaríem, no? Des del punt de vista de la pròpia naturalesa jurídica de la responsabilitat, efectivament, perquè la presumpció general, la llei de societats anònimes, és, en principi, la responsabilitat per negligència, excepte en els casos específics que la llei contempla una responsabilitat objectiva, que seria la strict liability dels Estats Units, i per tant aquí jo crec que això tindrà caràcter excepcional. Per altra banda, estem parlant d'un reial decret, que per tant és un reglament, que per tant difícilment pot derogar o modificar en res no solament el 1902 del Codi Civil, sinó també el que jo crec que seria no tant responsabilitat extracontractual, sinó contractual, derivada d'una emissió d'augment de capital o d'una compra d'accions, etc. I per tant, al final seria responsabilitat, i tant des del punt de vista del 1902 com del 1101, 1102, etc. del Codi Civil, doncs estaríem parlant d'una responsabilitat per culpa, negligència o dolo. Això que determina que en la nostra praxis hi ha una certa tendència, que jo crec que és el que ens ha de convidar a la reflexió, a apropar aquesta qüestió i l'exercici d'aquestes accions a l'àmbit penal, quan realment és un tema estrictament mercantil civil. I per tant aquest és el tractament legal que tant des del punt de vista processal com des del punt de vista substantiu se li hauria de donar a una situació, fos de frau, fos de negligència, no necessàriament d'una situació dolosa, i per tant aquest tractament de la responsabilitat em sembla un punt de partida fonamental per evitar precisament arribar a que haguem de cometre un delicte i per tant hagi d'haver dol o realment una culpalata, no?, que ens porti a una situació delictiva i per tant doncs, que la via mercantil sigui la idònia per a l'exercici d'aquestes accions. No sé què us sembla això.
Sí. Bueno, hi ha la distinció entre el que és la responsabilitat per l'emissió del folleto i en canvi l'altra que és la responsabilitat per la informació, que tenen un tractament una mica diferent i que m'ha semblat curiós. En aquest cas, als Estats Units és més clar, no, Marvin? És només responsabilitat objectiva, strict liability, en l'emissió, en la sortida inicial a cotització o negociació dels valors. En els altres casos no és responsabilitat objectiva, sinó que s'ha de provar el frau, o s'ha de provar el dol o la culpa de l'emissor. No és això?
Yes, that's true. The strict liability statute is only for public offerings, new securities. So if a company is trading on an exchange, there is no strict liability for materially false and misleading statements. Any statements that artificially inflate the price of the security, sorry, I was getting a little feedback there. Hearing myself speak is frightening sometimes. There is no strict liability for those types of securities, for raising the price of the security beyond which it would be trading. There is strict liability for new securities. So in that case, a different type of security, not previously issued, there would be strict liability for that new security. And that new security has a different statute of limitations and has different requirements than the old securities that were already being traded. And that's true even for more of the old securities that are offered in the market. So in common stock, you have the initial public offering, and then later on there may be secondary public offerings. If your security is the secondary public offering, you can get strict liability, but it has to be those securities that were purchased from an underwriter on the secondary offering. Whereas if it's a new type of security, of course, it's easily traced back to the offering because it didn't exist before. And even that gets confusing because there's something called Rule 144 securities that may have existed and held in private hands, and that may defeat the strict liability statute. You're primarily looking at a fraud statute, which again has more onerous requirements. It has that scienter requirement that you had to have intended to prove fraud, and it's not easy to prove that you intended to prove fraud, that the defendants intended to prove fraud. You never find a document saying, well, I don't want to say never. Once in a while you do find those documents. We found them in emails in the Merrill Lynch analyst litigation, where the analysts were sending to the investment bankers emails saying, we better get out of these terrible securities, but they used worse words than terrible. We better get out of these terrible securities, and yet they would put out public statements that saying, please buy, these are great securities, while at the same time they were sending internal emails out. But generally, you don't find that.
Gracias. Alguna pregunta des de públic? Endavant.
Mr. Frank, I have a question for you. If I understood correctly, you were explaining that your friend lost $125.
Están trayendo. Espera un segundo porque hasta que no tengas el micrófono no lo pueden traducir desde la... Bueno. Y además así lo veremos todos mejor.
Sí. No, I will repeat the question. My question is the following. If I didn't understand correctly, but if I
No se oye,
correctly,
no se oye.
Hola.
Ahora sí.
If I understood correctly, you were explaining a case in which a friend of yours lost $125 in the stock exchange. He called you and told you, I have lost this money, and you told him, let me help you in this litigation, and he got back $40 million US dollars. I didn't understand it correctly, probably.
No. At the end of the day, he actually got nothing. Because there is a limitation on how much that we will pay a person. So we don't cut checks for anything less than $10. And it turns out he lost because of that was a strict liability case because it was an offering, but he lost because of the misstatements in the prospectus, about $9.50. So he didn't get anything back. But there were thousands of people among which the $40 million, among whom that were distributed.
Now I understand. Thanks.
Señor.
Allí hay dos.
Allí y allí.
Thank you. Hello? Yes, it works. Thank you. I have a question. Here is normally unusual for a lawyer to invest money on cases of a client. And you were saying that in some cases you have to even advance a lot of money. What happens if the plaintiff changes the lawyers? Is that something that happens often? And then I would like to ask a second question, because I also had the wrong misunderstanding. And I thought that this client of yours that lost $125 received the $40 million. So basically, you, the client, can only get as much compensation as he has actually lost, like it's here, basically. We were not talking about any punitive damages or anything like that. The money that you lose is the money that you may get back.
See, that's the purpose of the class action, that the money that is lost is not your client's amount of loss, it's everybody who purchased the securities loss. So it's aggregated damages. In the case of that I was talking about, where my client lost a minimal amount of money, there were $1 billion worth of securities floated. They were $25 a piece, so what is that? My math is lawyer's math. It's not very good. So it's whatever $1 billion, it's actually $1,100,000,000. There was an overage, divided by $25. It's a lot of shares. And we were able to get a certain amount of money back for everybody who purchased on that offering. And that's the difference. That's what a class action is, and that's the purpose of the opt-outs. That even though those thousands or tens of thousands of individuals who purchased the securities did not come forward, we got them money. And at the end of the day, we mailed them notice because, of course, in a securities class action, we know who bought the security. At some point in time, the defendants have to give us the names of all the purchasers. And all the brokerage houses know who they are. Or actually, they're all kept at the Depository Trust Company in New York. So DTC has those because you have to send out end-of-year tax forms and whatever. So we sent it all out to everyone. And we also published notice. And in worldwide class actions, we put out notice in every country in the world in which we think that somebody purchased the security, and we have it translated, the notice translated into that language, and the negotiator is a fairly comprehensive document approved by the court and negotiated between defendants and plaintiffs, because if there's a settlement, they don't want to ever admit liability or, whatever. So everybody had the opportunity to find out, but they frequently don't want to know. There was an institution in New York that we knew who had purchased a substantial amount of securities on an initial public offering, because that's public information. And I called the CEO of that company, the chief investment officer, actually, of that investment company, and said, "You own $3 million of this security. Did you know that?" And he said, "No, we don't." And I had a fight with him for about 2 weeks to prove to him that he actually owned it. And then he said, "Oh, yeah, you're right." He didn't know, which is frightening to me, that he had no idea he had purchased millions of dollars of the security, but that's the way it is. You asked another question about plaintiffs changing lawyers. In fact, that does happen. And what do? It doesn't happen very frequently, so there are no standard rules. The law is, in the United States, if a plaintiff changes lawyers, or anybody changes lawyers, you're entitled to your something called quantum merit proportion of success. And what that means, in English and not Latin, is you get your benefit of your bargain. If you did half the work, you're going to get half of the fees at the end of the day. Now, it gets a little trickier as to what happens to the expenses. Generally speaking, the more expenses there are, they happen later in the case, because the most expensive thing about a case, in the Williams case, the $125 case, there was about $8.5 million worth of expenses. And they were primarily incurred later in the case by experts and by the document reviewers, hundreds of document reviewers going over the documents. I really haven't come across a case that was lost in which there was an issue over who pays for the expenses. Because if I were the attorney being replaced and the case was lost, I'd be concerned that it was lost because of the actions of the new attorneys, and then they're costing me money. So I negotiate that up front and try to get reimbursed by the new attorneys first. If I spent $1 million on a case, and then the plaintiff decides to replace me, first of all, he's got to get court approval, and I could fight that. Okay. Secondly, if that were the case, I'd make him give me my money back so that he has something at risk.
Thank you. Había una pregunta.
Si pudiera hacer una pregunta al profesor Peláez, solo. Sí. Bueno, la pregunta básicamente es, ha planteado muy claramente que es muy restrictivo todo el ámbito de las acciones colectivas, y lo que pasa es que ha habido alguna posibilidad que se has apuntado sobre que sí que un despacho podría organizar una acción de este tipo, pero no me ha quedado muy claro exactamente en qué caso y cómo se podría, en qué casos y cómo se podría hacer. Es decir, aislando lo que sería la asociación de consumidores, etcétera, ¿cuándo podría un despacho normal agrupar a una serie de afectados, un tipo de plataforma, y entonces plantear una acción de tipo grupal o colectiva?
A ver, el supuesto es tan solo en el caso de que defiendas un interés colectivo, o sea, que los consumidores y usuarios afectados estén determinados o los puedas determinar con facilidad. En ese supuesto, la ley dice que puede actuar ante los tribunales no solo la asociación, sino el grupo de afectados. Y el grupo de afectados tendría que ser a través de alguien que lo haya agrupado, valga la redundancia. Entonces, en este caso es donde podría, gastándote los cuartos.
Muy bien. Adelante, por favor.
Gracias. Brevemente para el señor Valls y el señor Peláez, aunque si hay algún comentario de Marvin también lo agradecería, ¿no? Pero es un tema simplemente en España, ¿no? Recientemente aquí está de moda el tema de Madoff y el tema del Banco Santander, puesto que hay unas inversiones y unos inversores que se consideran que han sido engañados, ¿no? No obstante, según todos los papeles que firmaron, en principio asumían un riesgo, y además alto. Resultan ser personas aparentemente de muy alto patrimonio, ¿no? Y más que la acción jurídica o la acción judicial, por cuestiones comerciales o de imagen, el banco parece que les va a tratar de resolver o minimizar el problema, con independencia de que en Estados Unidos hay inversores que no están de acuerdo con la propuesta del Banco Santander. Dicho esto, que es un poco lo que está de moda y me agradaría un poco saber la opinión sobre este tema, yo diría que aquí en España se han producido en entidades muy conocidas exactamente lo mismo que con Madoff, pero con fondos de inversión. Algunos monetarios, por ejemplo, fondos de inversión con capitales de 2.000 millones de euros que han perdido un 20%, o sea, 500 millones de euros. Y además lo han perdido en un mes. La pregunta sería, los inversores que han invertido en estos fondos, ¿son consumidores y usuarios respecto a la ley española o, como no están en Madoff, no pueden recurrir? Esta sería un poco la pregunta. Hablo de un fondo monetario, vendido como alta seguridad, además que invertía en letras del Tesoro y que se desmarca con un 20% de pérdida. 500 millones. De 2.000 millones se queda reducido a 500 millones. No he dicho el nombre, pero voy a decirlo porque a lo mejor cambia la aproximación al tema jurídico, porque no soy jurista. Se llama Banco Santander Emilio Botín y el fondo es Santander Corto Plazo Plus. 500 millones de euros.
Bueno, aquí se trata de... hay que analizar el supuesto concreto, que es si el inversor ha ido al banco intermediario, que a su vez le ha recomendado este fondo monetario que ha tenido la pérdida del 20% posterior, o si ha invertido directamente por decisión propia, etcétera. O sea, hay que ver si un supuesto como si ha comprado en un mercado o si ha sido una recomendación del intermediario. Si es una recomendación del intermediario, entra una normativa que ya he dicho antes totalmente distinta, una normativa donde, para simplificar, tendríamos que analizar si la entidad que ha recomendado esta inversión ha cumplido sus deberes como comisionista bursátil, como conocedor frente a su cliente minorista de todas las circunstancias, la ha informado de los riesgos y se ha informado bien. Esto es el análisis de la directiva MiFID, fundamentalmente. Si se trata, para ampliar el supuesto, de la adquisición de unos valores en el mercado, lo que tendríamos que ver si es la caída del 20% es debido a o falta de información o omisión o falsedad de la información, o es debida a los avatares del mercado. Si es debida a los avatares del mercado, entramos, evidentemente estamos otra vez fuera del supuesto. Si es debida a omisión de información o a falsedad en la información, entonces sí que teóricamente se activan los supuestos de responsabilidad que hemos expresado anteriormente.
Muy bien.
Hola.
¿Alguna pregunta más?
Sí. Es una pregunta para el señor Marvin Frank. Está relacionada con el tema de las ADRs y concretamente sobre la competencia de la jurisdicción americana. En aquellos casos concretamente de compañías españolas que no cotizan en Estados Unidos, pero que bancos americanos distribuyen ADRs de estas empresas. Un poco es comentar la competencia jurisdiccional americana, cómo funciona concretamente.
I'm not sure I understand the question. The problem I'm having, you're talking about Spanish companies that are not traded in the United States for which American companies distribute ADRs, and there is no such thing. At least I'm not aware of it. I believe American depository receipts that I'm aware of are the shares of non-U.S. companies that are somehow aggregated in the United States. So sometime it's, let's say it was Banco Santander, and let's say they may be 20-1. So there may be 20 common shares traded in Europe put together in one American depository share that are traded in the U.S. exchange. And that's the way I understand an American depository share, or American depository receipt and an American depository share are the same thing. So it has to be traded in the U.S. Now, if American companies are distributing some other type of security that's traded elsewhere, I'm just not aware of it. I'm aware of the ADRs when they're traded in the U.S., then the Securities and Exchange Commission, the SEC, gets involved, and those companies have to file annual reports. They're not called 10Ks for American companies. They're called 20Fs, and they have to file quarterly reports and immediate reports, the equivalent of an 8K if something happens. But those shares that I'm interested in are the ones trading on some American exchange.
¿Hay otra pregunta? Sí.
Another question.
Sí, sí, sí.
Can you hear me?
Oh, we speak English, yes.
Okay. But is this working? Okay. No.
I don't think it's working,
No.
but I can hear
Okay,
you.
I'll shout.
Okay.
Okay. Well, another question for you, of course. I have a procedural question. If I am a holder of securities which may be affected by a class action, when and how do I learn of this class action, and when and how can I opt out if I want? This would be my first question, which is a procedural one. The second question would be, other than to pursue an action on my own, why should I want to opt out?
For the first question, I can think offhand of 3 different times that you would find out. Okay, after the lead plaintiff is determined, the court picks the lead plaintiff, and that's generally the individual or institution that came forward within the statutory period, 60 days from the filing of the first complaint, and asked to be lead plaintiff. After that, then a motion to dismiss is generally filed by the defendants. If they don't file a motion to dismiss and just answer the complaint, then you know you've got a big problem, because the only time that happens is when the company has no money and no insurance. So you've got a real problem. But generally speaking, they'll move to dismiss, that there's no legal basis for the complaint. That that gives us the opportunity to oppose it. Then they reply. Then the court hears oral argument on it. Generally, courts throughout the country do different things. And you may not even find out what the ruling on that is for six months or more after that. You're not allowed to start discovery or do anything else until that's determined. The thing you generally do thereafter, after you've won the motion to dismiss, by the way, if you lose it, you're generally given an opportunity to replead the case, to put in a new complaint, because the judge tells you what's wrong. And a lot of times these cases are so complex, the complaint may be 200, 300, 400 pages long, and he just doesn't understand it, so you have to reorganize it. That happened recently in the New Century Finance case, a subprime mortgage lender. And the second time around, we survived the motion to dismiss. And it's a standard procedure that you're allowed to have a second bite of the apple, sometimes more. After that, you get into discovery, you're allowed discovery, and you have to move expeditiously for class certification. If the class is certified, which is not easy, it's getting more complex, if you win that, then you have to send out notice that time. Okay? Frequently, however, that's delayed, well, let's continue. You send out notice. At that point, anybody could opt out. They don't have to at that point, but they can. You go through discovery, you go through summary judgment, and the case is tried. Okay. Another time that the notice is sent out that you would find out about the case is if the class certification motion were not made because it was delayed due to settlement negotiations. And that could take a year. So nobody's making that motion because you're trying to send out the settlement notice along with the notice of the case at the same time so that you save all of those processing costs, which could be hundreds of thousands of dollars. So it may be simultaneous. Okay? Now, if the class is certified, you go through discovery, and then you settle the case, well, then you have to send out the notice of the settlement. So you get the double cost. So sometimes you put it all together in one, because the defendants, if they settle earlier, settle less expensively because it's just less work has been put in and, less risk has been taken. You could settle it cheaper. There's a third time when you or your client can find out. And that's if you subscribe to our portfolio monitoring service. Marketing. We're here for marketing. Here it is. It's someplace in here, the portfolio monitoring service. Many institutions, most of the big institutions, tell us what their portfolios are, and we monitor them to see what's going on in the class action context. In our specific one, so there are a few law firms in this end of the business. It's a very specialized practice because it's very risky and very expensive. I mean, of course, for the Williams case, as I said, we laid out over $8.5 million. If we lost that case, it would have been very unpleasant. So not every lawyer gets involved in that. Ours, we do through ISS. I think they're called Risk Metrics now. They're Institutional Shareholder Services, which is a very large American, European-based, I think they're out of Geneva, or Brussels. Brussels? Oh, okay. I'll finish this up. Where they do all the proxy solicitation work for companies, so they're known for their ability to keep their mouth shut and keep confidential documents and so forth. We use them they have a service, and you would get an email, your client and you would get an email telling you that a case has been filed for a security that you're holding. So there's three different ways.
Carlos?
Why should I want to opt out? Other than
You could frequently get more. When a case settles for X percent of damages, an opt-out will get more. It's a matter of they want to put everything to bed and they know they got to pay you more. But you can only opt out if you've got a significant claim. I'd say $10, $20 million and up.
Thank you. Rodolfo, potser podríem intentar acabar les qüestions en el petit còctel, no?
Sí, efectivament. Si us sembla bé, doncs a partir d'ara tenim un còctel on podeu seguir preguntant als ponents. Jo vull agrair a tots els ponents estar avui amb nosaltres, haver vingut aquí. Very especially to you, Marvin. Thank you very much indeed for coming to this session with us. You will be very welcome when you want to come again, so we are really satisfied with very instructive and informative everything. And okay, I hope you enjoy your time here in Barcelona. Okay.
Thank you very much.
Gràcies per favor.